Hello, my name is Tzanakopoulos and I'm an Associate Professor of Public International Law here at the University of Oxford. Welcome to the BCL MJUR. I am here to talk to you about a long-standing course in our BCL MJUR International Law curriculum, which is called International Law and Armed Conflict. It's not International Law in Armed Conflict, it's International Law and Armed Conflict, and the reason is simple. The reason is because in this course we deal with two distinct and separate questions that revolving around how international law applies on the run-up to and during armed conflict. So the first part of the course, which you could call it recourse to force in international law, or what we usually call in Latin, because lawyers and lawyers like to talk in Latin, it gives them more gravitas, it goes with the beard, is called the jus ad bellum. So the law regarding recourse to force. Essentially, in this part of the course, we will look at how international law regulates the right and ability of states for using force in their international relations. We will discuss the basic rule in international law, which is the prohibition of the use of force in international relations, as provided for in the UN Charter and in general international law. But then we will go on to look at one of the most major exceptions to that prohibition, which is the right to self-defense. And we will discuss this right of self-defense in quite some detail, including questions of what we call anticipatory or preemptive self-defense in some cases. We will look at questions of self-defense against non-state actors, if such a thing exists, and so on and so forth. We will also look at other exceptions or other putative exceptions to the prohibition of the use of force in international law, including, for example, what is sometimes called protection of nationals abroad, what is sometimes called intervention upon invitation, and what is sometimes called humanitarian intervention and its relationship to the so-called responsibility to protect, or R2P if you're texting it. That is the first major part of our jus ad bellum part of the course. The second major part of our jus ad bellum part of the course relates to the use of force in the context of the UN Charter and under UN auspices. So we will talk about the power of the Security Council under Chapter 7 to authorize the use of force by states for the purposes determined by the Security Council, and we will deal with all the details regarding this particular, sometimes called exception, or this particular way for states to use force lawfully. But we will also look at other contexts in which the UN is important, such as, for example, peacekeeping, or what is sometimes called Chapter 6.5, just before Chapter 7. After we have dealt with these issues regarding the jus ad bellum, which is usually done in the first term, so in Michaelmas term, then in Hillary term we'll switch mode, and we will then properly talk about international law in armed conflict, so how international law regulates the conduct of hostilities once armed conflict has broken out. What is the law that applies? This is, again in Latin, called jus in bello. It's sometimes called international humanitarian law, though there's not very much humanitarian about being told by what kind of bullet you are to be killed. So it's a bit Orwellian, or you can call it the international law of armed conflict, or the law of armed conflict. There we will discuss the concepts of international armed conflict, the non-international armed conflict, the categorization of armed conflicts, that means, and we will also deal with problems about the transnational use of force, which doesn't neatly fit into either an international armed conflict or a non-international armed conflict, problems created by terrorist groups using force, states then using force against terrorist groups in various states, and so on and so forth. That's one part of the course. We will also cover the so-called Geneva Law and the so-called Hague Law. the Geneva Law dealing primarily with questions of humanitarian treatment of civilians in armed conflict, questions of prisoners of war, and so on and so forth. And the Hague Law dealing primarily with conduct of hostilities, means and methods of warfare, and questions of targeting, weaponry, and so on and so forth. We will complete this part of the course by dealing also with the application of human rights in armed conflict, and how this relates to the law of armed conflict, to international humanitarian law, how these two parts of the law operate together in the context of an armed conflict. But we will also discuss the responsibility of states and international organizations for violations of the law of armed conflict, and so on. Essentially, the course is structured like a standard BCL MJUR course. That means 2 full terms of seminars every week in Michaelmas and Hillary term, and probably 2 or 3 seminars in Trinity, and 4 tutorials. Now, the course will be taught by a group of people, including me and another 2 or 3 colleagues, depending on how we structure it this year. And it is examined by a 3-hour exam, written exam at the end of the year. So if you're interested in questions of use of force in international law, I expect to see you in class very soon.